I'm going to introduce John for those. That.
Good morning and welcome to our May 24th meeting. Does anybody have comments or questions about the minutes from our public session from our meeting of April 26th? If there are no questions or comments, I'll entertain a motion to approve the minutes. Is there a second?
Second.
All in favor of approving the minutes from the public session of the April 26th meeting, raise your hand. Any opposed?
Commissioner Ralph Harris.
Seeing none, the motion is approved. Seth, you have some items that you're going to lead us through.
Sure. First, I had mentioned at the last meeting that I'd had outreach meetings with, well, I've met with each conference in the legislature, including the Independent Democratic Conference in the Senate, the Republican conferences in the Assembly and the Senate, and the Democratic conferences. So I completed those this past week. And I have also had a series of meetings with the City Bar, NYPIRG, Common Cause, and some other folks too, just to establish some kind of connection with them, and looking for comments and suggestions from them on the commission. Just to talk about the legislative conferences. That, by the way, that includes the Legislative Ethics Committee. One of the topics was the financial disclosure regulations, which I understand were vetted, a draft was vetted several months ago. We are in discussions with them, and we're going to be soliciting more comments, certainly through the SAPA process. We hope by June to have a proposal for the commission to consider on dealing with the issues of client disclosure. I've mentioned these to the, and we've had discussions with the conferences on the substance of those. I guess one of the interesting issues is making sure the regulations really do match the statute. There were issues about what the statute said and what should and should not be included. The exercise is really to make sure the regulations implement what the statute and what the law requires. Our hope is to have some consensus for the commission in June, and then solicit more comments from the public and other groups through the SAPA process before they become final. It's important because our next filing period is these will impact those, and especially individuals who have clients in the area of certainly lawyers, but other similarly regulated type activities need to have this information in order to advise their clients on what will and will not be disclosed. So that's going to be coming up in the June meeting. Various groups that I met with, I tried to distill some of their comments and some of their proposals. I have really three different areas that they made some substantive change or substantive proposals on. Obviously, there were things that they discussed that are not something that the commission can do, which is changing structure. I know Commissioner Jacobs had mentioned last time that we could certainly make recommendations on changing structure, and in terms of making legislative recommendations at some later point, should the commission vote on it, that's certainly within the prerogative. The exercise I went through with these groups was looking for ideas on how to effectuate the purposes of the commission under the current structure and under the current law. And they all related to, well, two of the three related to lobbying. They all expressed a concern with what they called shadow governments consultants. They were certainly favorably disposed towards more active regulation of lobbying and consulting. There were comments made about open meetings and subjecting to FOIL. We know there was some legislative, the governor had a proposal dealing with those issues in the executive budget. Those were brought to my attention. Of more interest was, immediate interest is the use of Public Officers Law 74-3H, the raising suspicion section in the Code of Conduct. There was a general consensus that that was something they believed we could use more and should use more in evaluating conduct. Some of the suggestions were fairly specific, but in general, they thought that more use could be made of that. I noted to them that we actually, JCOPE has proposed adding some teeth to that. Right now, there are no real penalties for violating 74-3H. There was a proposal from the commission to actually treat those as other violations. I believe it's up to a $10,000 fine that could be levied for those violations. JCOPE, but also there were proposals made about adding and fleshing out the concept of accomplice liability in general for violations of the law, the public officers law and the lobbying law. We thought that, and the commissioners thought that those would add some more substance to the enforcement capabilities of 74-3H. In terms of actual practical applications for us, they are all very supportive of the commission's efforts in the area of lobbying, lobbying regulation, and have just encouraged us to do more. And we actually do have other proposals that have gone over to the legislature in terms of amending the lobbying law, and those were pointed out to them as well. So I think that whether any of those are implemented, we'll await the outcome of the legislative session. But those were the essence of the discussions that I had over the last 3 weeks or so. If anyone has any questions or anything I can answer? Anything you'd like me to ask them? All
right, let's go to the next item. Thank you.
right. Staffing. Over the last few weeks, we've been trying to put together a meeting of the management.
I think Marvin
Oh, I'm
raised his
sorry.
hand.
Oh,
Marvin?
Yeah, I was just asking, how was it all left? Who was supposed to go forward with what and on what?
in terms of the suggestions that were made by the groups,
Yes?
I said that I would bring them back to the commission. In terms of how the commission proceeds, I've conveyed that. The ball certainly is in our court. They're not going to do anything about regulating lobbying and dealing with the various issues that were raised. Those are the activities that the commission is actively engaged in now. We have, within the last 2 weeks, have recommitted to putting the changes that we have suggested in the lobbying law back on the table, with the idea that the legislature might be taking those up. We're also actively working on lobbying regulations, so we will have, during the course of the next few months, comprehensive lobbying regulations I'm sure that they will comment on, and the public will as well. So the ball is in our court.
Seth, can I ask a question? You said that in your meeting with the civic groups, there were concerns about the shadow government. Can you give us a little bit more detail about what specific concerns the good government groups had with the shadow government? What were they talking, for example, about particular branches of the government, particular divisions or departments, city versus state, for example? If you could amplify.
Oh, absolutely. The concerns that were raised had to do with the use of consultants. I'm actually taking the term shadow government from one of the group. Actually, two of the groups used the term. They were concerned with consultants, qua lobbyists, who operate in the shadow and under the protection of and quite frankly, discussions had to do with specifically with municipal and city government. But I imagine it applies to any place where that might exist.
Did they single out any particular municipalities?
Yes,
or
New York
cities?
City. They were talking about New York City in particular. In fact, they were talking about newspaper articles dealing with some various entities in New York City, and they were concerned that by hiding in the shadows and operating as a government entity, that created a real difficulty. They were actually they were pleased with the advisory opinion to the extent consulting itself could no longer not call itself lobbying by calling itself consulting. I think one of the comments was that if it quacks like a duck and has feathers like a duck and it walks like a duck, it's a duck. Well, the same thing with lobbying, no matter what they call themselves. And the concerns were specifically addressed towards some of the events in New York City.
Thank you. Unless there are any other comments or questions about Seth's outreach meetings, which I think sounds very productive and good for the commission, good for the groups, it's been long needed, and I think we're all very grateful that you've been able to do that and hit the ground quickly. Can you talk to us about the staffing items that you wanted to raise?
Sure. Since the last meeting, so I'd say the last few weeks, been trying to put together a meeting of the management committee, and the stars have not aligned productively at this point in terms of getting schedules, but I think it's imperative from a staffing standpoint that we get a meeting together to discuss staffing issues. There are two that I'd like to bring to your attention right now, and they're line attorneys. There's, as I understand it, I guess there's no delegation now to the executive director to do that. I'm not looking for senior level attorneys, but we do have two line attorneys in the advice, John Harford's provision, rather his division. We need help. We do need the assistance. My thought would be, and I would like to present to the management committee a reorganization, but it would not change the need for these attorneys. And I don't think my proposed reorganization will cost the commission anything outside of its current budget either. But I'm looking to hire two attorneys who can assist in advice, counseling, but I'd also like them to be double threat individuals, looking for individuals who can also double as investigative attorneys. We've been busy. Business is brisk. And if we could have attorneys that have an investigative background through either a prosecutor's office or something similar, but also have that background in ethics, that would be ideal. I can tell you that the folks, and we have well over 100 resumes. We have over 100 resumes. Although I don't think it should be a disqualification, I don't think we're not looking to hire, and I know these issues have been raised, folks from the executive chamber, so I'm not looking to hire anybody from that. I would like to get someone with state experience and government experience, but I think we can get folks that fit the bill, that'll do the work, and not raise other, I would say questions, but I don't necessarily think they're necessarily a problem. But I think that there's enough talent out there that we can do that, and I'd like the ability to fill those two positions. So the junior auditor positions, some of those others we're able to start filling now. I know with the break in executive directors, there was a lag there, but we need the help. We've got the money, and I'd like that ability.
Any discussion or questions? If there aren't, then I'll entertain a motion to, how many staff do we need? Three?
Two
attorneys.
Just two line attorneys. These are
To
not.
permit the staff to interview and hire two staff attorneys. George?
Now I have a question. I didn't know there would be a motion. What would be the salary level? Because that's something we've been playing with over time.
I mean, in general, the salary levels range for the attorneys based on their experience and how much the experience they have and how many years of practice they have. But, you know, probably somewhere in the 90s to the low six figures.
So if they weren't, let's assume for a moment that they were not policymakers. So will
Our
they?
lawyers are all policy.
No.
Oh, okay.
I said assume for the moment.
I gotcha.
Would they be breaking the threshold to require for the filing of an FDS?
Yeah, 90, is it
It's
90 something?
It's 91,
Yeah, it's
so,
90, it's- yeah,
so it's
that's why-
right in
Yeah,
that
it
ballpark.
would be just above that threshold. It could, yeah.
Because I think that was the litmus test we had used previously in this interregnum period.
Well,
No, we
yeah,
actually-
no, we didn't. Go ahead. I mean,
Yeah.
just to a couple of points. I mean, it would be good if we can get the management committee members to agree to meet, because,
Yeah, that would-
you know, this would make our meetings be more efficient, and so that everybody remembers, George is right, whatever the litmus test was, there was a period last summer or last fall where the commission decided that in the absence of an executive director, the commission effectively wanted to make the decisions that were normally delegated to the staff for hiring, except for the most ministerial positions. Presently, and I think this is what Seth was alluding to, we're still operating under the construct that the commission agreed to. And so the staff is not able to hire lawyers right now. But before Seth comes to us and presents a more comprehensive staffing plan, we have these immediate needs, given the fact that we're very busy and there have been departures, that we really do have these immediate needs. So, Monica, I mean, I would ask you to remind us what the above the line, below the line, which is I think how we phrased it, threshold was for what are the limits of Seth and the staff's authority to hire without our approval right now.
Right. I think we avoided using the term policymaker. It was, people were using it colloquially, like
Yeah.
non-policy making individuals, but we actually made very clear we're not talking about policymakers in terms of 73 and 74. So we just meant line level people. But right now, the authority is to hire auditors, staff and admin, but there aren't any vacancies there, and, you know, and staff in the filing specialist unit, so FDS filing specialists and lobbying filing specialists. Just so everyone understands, we currently have at least 11 vacancies. So, and at least four of those under the current plan are legal positions. So we really do need lawyers. As you know, we've got a lot of different legal issues going on and investigations going on, and so that's why we're coming with a special
And we really need
request.
to have a management committee meeting. And I appreciate that everybody's busy and has complicated lives outside of the commission. And I'm grateful to everybody, you know, who volunteers for these committees. However, if it becomes, you know, too much of a burden in terms of scheduling, I'd ask those members of that committee, if this is not going to work for you time-wise, let me know and I'll find somebody else to take your place. But we really do need to get that committee going. So in any event, what other questions do folks have about this immediate issue that we've got? Sorry.
There's a question here.
Dawn and I are kind of confused. I think I'm on the administration committee, and I think Dawn is too. And are you going to schedule a meeting or not?
Yeah, well, I haven't attempted to schedule, but there have been efforts by Deb to call each of you, and we don't need to go into the details, but my understanding is that there were, let's say there are 5 members of that committee. 4 members were available on a certain day, and a 5th member said, I'm not available, and we couldn't come up with an alternate date. And I don't think we need to take the time, you know, I don't want to take your time in this meeting to come up with dates, but I encourage you each to look at your own schedules and figure out what you can do. The management committee does need to meet, but because it hasn't been able to, for whatever reason, we've got to make a decision about this request that our executive director has made to hire 2 staff lawyers. So George had a good question. Anybody else have questions about Seth's request?
motion's still on the table.
Well, no, somebody needs to move. And if,
I move.
okay, Commissioner Romeo moves to give the staff authority to hire two line attorneys. Is there a second? Commissioner Knox seconds. All in favor of the motion? Pardon me?
The authority is to give staff authority, or is it to give the executive director authority?
It's the delegation to the executive director.
Okay, thank you.
Which is what our staffing plan and the statute authorize, or our original staffing plan. Unless there's any other discussion, I'll put it to a vote. All in favor of Commissioner Romeo's motion, raise your hand.
Deb, did you get everyone?
See everybody's hand up. Gary's up. Gary's not.
All right. Yes. Any opposed? All right, the motion carries unanimously. Thank you.
Thank you.
All right, next item is an update on the Kinn hearing. Who's going to take us
Monica.
through that? Monica?
Yes, sorry. As you'll recall, the commission issued a substantial basis investigation report in the matter of Tracy Kinn, and I just wanted to advise the commission this is now a public proceeding. We've noticed a hearing, which will be a public hearing. I'm sorry, I had the notice and I'm just trying to find it in my papers. There we go. We noticed a hearing for June 1st to be conducted in the Buffalo office of J-COPE. As you know, our rules provide that we select an independent hearing officer, and we have a pool of hearing officers from whom we select that were selected by a committee of our commissioners. Right now, we have 7 hearing officers, and we have an outside contractor that we use, which basically, when we need a hearing officer, does a pull and provides a list to us randomly in order, in a random order of the hearing officers, the 7 hearing officers, and we start with the first person to see if they're available and that they don't have any conflicts and can conduct the hearing. As it turns out, once again, Judge Pratt was selected to be our independent hearing officer. So it's coincidental, and that's truly a random process. And so Judge Pratt is the hearing officer. He held a conference yesterday with the counsel for both sides. Emily Logue, investigative counsel, participated for us. Due to conflicts with some of the witnesses, it's going to actually be adjourned, so it will not take place on June 1st, and the parties are going to reconvene after June 8th to determine a hearing date, and we'll keep you apprised of that.
Thank you.
Are there any questions?
Questions or comments? Okay, thank you. All right, so we're in for a special treat. The staff has prepared a presentation for us that I believe that we requested at one of our meetings a few months ago, which is to walk us through the permutations and requirements for the 2-year bar. And I think John Horford's going to do that. So without further ado, I'll turn it over to John.
Just the commissioners who are participating through WebEx won't be able to see.
Do we have a handout?
Yeah, but we couldn't get to them, so don't worry about it.
Well, John will.
He'll cover. Yeah. There you go.
Good morning.
Good morning.
I should probably begin with an apology. When Seth asked me to put together a presentation to walk you through the 2-year bar, I sat down to create a PowerPoint. I took a look at that PowerPoint this morning, and I put so much in there, it would probably be worth about 2 hours of continuing legal education credit if I went through everything on every slide. It is not my intention to put you through that torment. I'm going to walk you through it. Obviously, if there's something on the slide that I'm not giving an appropriate amount of attention to, let me know. I'll be happy to go into more detail. Dealing simply with the 2-year bar in this presentation. 73-8A sub I. To summarize it, basically the 2-year bar has 2 components to it. There's an appearance component and there's a backroom services component. The appearance component prohibits former state officials and employees from appearing or practicing before their former agency within 2 years of their termination from state service. The other important point about the appearance component of the 2-year bar is it applies regardless of whether or not the individual is going to be receiving compensation. Then there is the second part of it, which is commonly referred to as the backroom services prohibition. That prohibits former state officials and employees from being paid to perform any services on behalf of a client in relation to a matter before their former agency, even if it doesn't involve appearing or practicing. An important distinction is this prohibition does not apply if the individual is engaging in those services for free. There have been, I think, 345 formal advisory opinions issued by the various incarnations of the State Ethics Commission. About 120 of those have been devoted simply to the 2-year bar. I can also tell you that a significant amount of the requests we get for informal opinions also relate to specifically the 2-year bar. Post-employment restrictions in general, but mainly the 2-year bar. The Commission began addressing the 2-year bar pretty early on in its advisory opinions. In fact, the very first one, 8801, it's not up here, but in the very first opinion, they're confronting the 2-year bar. And they began by sort of setting forth what the principle is they were going to apply in interpreting exactly what the statute meant. And it got distilled down over the first year or so until we have the language in 8905, which is cited over and over again in subsequent advisory opinions discussing the 2-year bar. And simply put, the purpose is to create a cooling off period. And then you have the quoted language, to preclude the possibility that a former state employee may leverage his or her knowledge, experience, and contacts gained in state service to his or her advantage or that of a client, thereby securing an unwarranted privilege, consideration, or action. Now that you've seen the principle, here's the law. Here's the statute itself. And as you can see, I've bolded out certain words and phrases in that statute. And these are the words and phrases that in applying the 2-year bar to any particular situation, the Commission found itself having to offer up an interpretation of exactly what these terms mean, as straightforward as they may seem just from reading the statute. So that's sort of going to be the structure of this presentation. I'm going to take you through these words and phrases and how the Commission over the years has interpreted them. These are the phrases. So starting with the first one, state officer or employee. While it seems a straightforward term, there's a specific definition of it in 73(1)I. I bolded subsection 3 simply because that applies to us. Officers and employees of state departments, boards, bureaus, divisions, commissions, councils, or other state agencies. There's an important carve-out. There's a specific statutory exception for people such as the commissioners in this room. Per diem or uncompensated members of boards, commissions, councils, or public authorities or public benefit corporations are not bound by the post-employment restrictions. As I said early on, the Commission found itself in situations where, although it seems a straightforward concept, you had individuals who they weren't sure whether or not they actually fit the definition of a state employee. So in 9503, they distilled the analysis in making this determination down to several factors, starting with the obvious ones. Are they paid by the state? Do they have the rights attendant to a state employee? Health benefits, participation in the pension system, But ultimately, what they came to focus on in this decision and in subsequent decisions is number 3. Whether or not the individual, regardless of who's signing their paycheck, is subject to the direction of a state agency in the performance of their official duties. So, in 9503, what you had was an individual who was hired by a recruiter. State agency had some issues. They contracted with a recruiting agency to staff the agency. One of the individuals they hired was the person that ultimately headed the agency. They entered into a subcontract with that individual. So technically, the contracting, the person running the agency was between that individual and this recruiting firm. However, they said that that individual nonetheless is a state employee, basically based on their duties. They confronted this again when they were dealing with members of the interest on lawyer account. Now, the interest on lawyer account entity is not a state agency. However, they made clear the issue is not whether or not the entity itself that they're working for can be defined as a state agency. Because the definition of state employee, if I went back, you would see, refers to a much broader list of entities other than simply a state agency. And in this particular case, they looked at what the legislative intent was, and although the state finance law defined them as a state agency, that was for purposes of Public Officers Law 17, that's defense and indemnification. Nonetheless, these are people that are on the state payroll and receiving state benefits, and number 3, most importantly, they're carrying out a public function on behalf of the state. They're exercising some element of sovereign authority. Again, this is the example I talked about before. Actually, I think I mixed up the advisories. This is the individual that was hired by a private recruiting firm. And again, it's not the amount of direct state compensation, but the person's relationship with the state agency that will determine whether or not they're a covered state employee. Early on, someone tried to make the argument that despite what the definition of state employees says, the post-employment restrictions should not apply to non-policy makers. So in this particular instance, it was a laborer with the New York State Department of Transportation who left state service, wanted to work for a contracting firm that had contracts with the state. They made it very clear here that in looking at the definition, there's no room to make a distinction between policymaker and non-policy maker. All former state officers and employees, without regard to level of responsibility or exercise of discretion, still a state employee. Similar argument was made with respect to the length of service. This comes up in the context of people that are hired by tax during tax season for a brief period of time, or people that are hired by the Department of Transportation for a few months at a time to do inspections on bridges and roads. They tried to make the argument that because of the length of time, the limited length of time, that they were employed by the state, that they shouldn't be considered state employees. Well, again, once again, the answer was no. The statute is unambiguous in this regard. It doesn't leave any room to make a distinction based on the amount of time that an individual works for the state. The next phrase that the Commission found itself confronting, former agency. Although it's the singular, the Commission pretty quickly realized that it is the nature of an individual employee's responsibilities that define whether or not they have more than one former agency. There are several positions within the state government where you may be on one agency's payroll, but you're performing duties and services with respect to a host of other entities within the state. And that a person could, in fact, if the purpose here is to prevent them from capitalizing on relationships and knowledge, that the concept of a former agency had to be somewhat broader, and at least include the possibility that a person could have more than one former agency. So they do look at what entity pays the employee. They do look at what entity provides the benefits to the employee. But the main issues are the bottom two. Who do they have significant responsibilities to? And in defining significant responsibilities, they focused on whether or not the person provides what they call continuing service, regular and continuing service of a non-ministerial manner. And that if an individual fits that definition, for however many agencies they have responsibilities to, that's how many former agencies they have when they leave. And the post-employment restrictions will apply to all of those former agencies. So there's several examples that I've listed here. Probably the one that comes up the most often is with respect to the MTA, because there's so many affiliates. There's New York City Transit, there's Metro North, there's the Long Island Railroad. And depending upon how high up you are in the MTA, you may have significant responsibilities with respect to those other entities. In those advisory opinions, 9533, 99-1, and 0304, they flesh out in each of those the extent to which they thought that the MTA employees' responsibilities to these other entities was significant enough, was continuing service to those entities such that the 2-year bar should extend to those agencies as well. And they also make clear that it can't be sort of intermittent service or sort of passing involvement. It has to be regular and continuing service in the course of their daily responsibilities that creates this notion of having more than one former agency. They dealt with it, I believe 9620 deals with the Commissioner for the Public Service Commission, who by virtue of having that title sits ex officio on 7 or 8 other boards, councils, public benefit corporations. So the question is, how many former agencies does that person have? It's not as simple as saying, listen, if you have the ex officio title, then therefore all of those entities are your former agency. Once again, they look to whether or not they're spending significant time or effort in those ex officio positions with respect to those other entities, and defining how many former agencies a particular state employee might have. Department of Economic Development is another example. It has several subsidiary agencies, I think 10. And depending upon the level of involvement with those entities, a person working for the Department of Economic Development could have 1 or as many as 10 former agencies. What I just covered was what they call the duty-based analysis, looking at a person's responsibilities and determining who their former agency is. However, they also apply in some instances, sometimes they apply both duty-based and function-based analysis in determining whether or not a person has more than one agency. The first place this comes up is in the context of SUNY, who I believe has something like 64 campuses throughout the state. So in looking at the structure of SUNY, what the commission concluded was each of those campuses, and the way that they're structured, and the way that they operate for most of those employees, does not involve any interaction with any of the other SUNY campuses. It may involve some interaction with SUNY central administration, but they essentially created a presumption that if you're working for one particular SUNY campus, that's your former agency. It may extend to the SUNY central administration, but it does not extend any other campuses, simply because there's no movement between them, there's very little interaction between them, and each of the campuses effectively, once they get their budget approved, operates independently. Then you have the Division of Tax Appeals, which they also concluded, based on its structure, how it's financed, how it operates, is sufficiently independent from the Department of Taxation that a former employee of the Department of Taxation, say an attorney, could still appear before the Division of Tax Appeals, but they're separate entities based on their structure and their function. Then you have, by contrast, 9520, an instance where they were dealing with the Unemployment Insurance Appeals Board within the Department of Labor. Essentially, they conducted the same analysis and concluded that it wasn't sufficiently independent to constitute a separate independent agency, and that if you work for the Unemployment Insurance Appeals Board, your former agency is all of the Department of Labor. Another context in which they have to apply the function-based analysis is when these agencies disappear or reorganize. These are several instances where agencies merged or their responsibilities were split up between various other agencies when they were reformed. And essentially, they look at the function and oftentimes also the duties of the former employee. And you could have a situation where you have not only more than one former agency, but the limitation and the prohibition is limited to the entity within the agency it's moved to. I know the way I said that makes absolutely no sense. I'll try to explain this a little bit better. Taking an example. You have the Medicaid Care Facilities Finance Agency. It's merged into the Dormitory Authority. So now you have a former employee of the Medicare Care Facilities Finance Agency who leaves state service and wants to know who their former agency is. Well, they hold that their former agency is the dormitory authority, but only to the extent that the dormitory is dealing with issues related to the responsibilities of the former Medical Care Facilities Finance Agency. Now it gets a little confusing. Same thing with the Department of Social Services. Transfer of a Medicaid program between the agencies meant that if you leave Department of Social Services, and when you were at Social Services, you were working with the Medicaid program. When you leave state service, you now have sort of 1.5 former agencies. You have the agency you worked for, Department of Social Services, but with respect to the Department of Health, you also are subject to the post-employment restrictions with respect to any matter in DSS, I'm sorry, in DOH, dealing with the Medicaid program. This is the concept of having more than one former agency taken to another degree. This is the special bar for executive chamber employees. There was a change made to the law in 2007, which sort of codifies this concept of having more than one former agency. And basically, if you're an employee of the executive chamber, when you leave, the 2-year bar is different for you. With respect to the appearance component of it, a former executive chamber employee cannot appear or practice for 2 years before any state agency. However, with respect to backroom services, that component of the prohibition, that component only applies to the executive chamber. So someone leaving the executive chamber can't appear or practice before any state agency. They can't perform backroom services for any matter in relation to the executive chamber. However, they would be able to perform backroom services for compensation with respect to those other state agencies that they still can't appear in. The other phrase, which is the subject of a number of advisory opinions, is the notion of appear or practice. What does it mean to appear or practice? Some examples: negotiating a contract with your former agency, submitting a grant proposal or application to a former agency, representing a client in an audit before a former agency. 9917 is an opinion that we rely on a great deal in analyzing the post-employment restrictions in terms of what it means to appear. As the advisories developed, they became very technical in defining what constitutes an appearance, to the point where there were advisories that held that any communication whatsoever with the former agency constituted an appearance. 9917 represents something of a course correction. It involved the Department of Transportation and an action actually brought by the Commission alleging a violation of the 2-year bar for a former DOT employee who was simply working on a road project and had a conversation with the DOT employee regarding a load of concrete. An action was brought against him for violating the 2-year bar based on this conversation. That was an appearance based on having communicated with the DOT employee in relation to this contract. The matter was challenged on an Article 78 proceeding, and essentially the court ruled in favor of the DOT, the former DOT employee. Basically looking at the strict interpretation of the statute and saying that the phrase appearing or practice should only reach efforts to influence a decision of the former agency or to gain information from the agency that is not generally available to the public, and it does not prescribe all contact with the agency. So in evaluating whether something constitutes an appearance before a former agency, when someone leaves state service and takes a job or is going to take a job and reaches out to us for an informal opinion about whether or not that new job constitutes or possibly might constitute a violation of the 2-year bar, because it involves some interaction with their former agency, what we're looking at is, what is the nature of the interaction? Is it such that they'll be attempting to influence the decision or the exercise of discretion of their former agency in any way? So here I've just listed some examples of what constitutes a prohibited appearance. These are just specific advisories that sort of flesh out what I listed in the bullet points. So working on an application or a proposal to be submitted to the former agency. Again, negotiating contracts or participating in audits, representing a client, writing or preparing or submitting a grant proposal to the former agency, with the person's signature is going to be on it, or the nature of what they're putting in front of the former agency is such that they're easily identifiable as the person who authored it. These things constitute an appearance. The notion that the former agency is going to see this person and they're automatically going to get some form of deference or special consideration just by virtue of who they are and the relationships they had when they worked for that agency. Even something as simple as submitting periodic status reports and billing invoices to the former agency constitutes an appearance. These are more examples. The first comes up in the context of, again, DOT contracts, where someone leaves DOT, they go to work for a construction firm, the construction firm is bidding on a state project. If, as part of that bidding process, they have to include that person's resume or their credentials, and DOT has to sign off and approve them, as part of that process, that constitutes a prohibited appearance. Engaging in settlement discussions. Contracting with your former agency. You see this oftentimes in the context of 8B applications. The agency can always hire the person back, but they can't hire them as a consultant. Again, the private entity has a contract with your former agency. Whether or not you can work for that company depends upon what your interaction with the former agency is going to be. And if there is any inference that can be drawn that the nature of your interaction is seen as an attempt to influence the way that agency exercises its discretion, you've got a prohibited appearance. Then there's the concept of work product that ends up in front of your former agency. So you've left state service, you're now working for a private entity, you are engaged with a completely separate agency in your dealings. However, you know that as part of the process, by virtue of statute, code, regulation, or policy, that what you're putting before that other agency is then going to be sent to your former agency for review. If that's a reasonably foreseeable result, that constitutes a prohibited appearance. So again, the issue is whether or not it's reasonably foreseeable that your work product is going to end up in front of your former agency. Permissible contact with your former agency. Providing general information. So you leave state service, you want to write a book, you want to provide a guide. It doesn't specifically address any particular application, but basically sets forth the process in dealing with your former agency, how to put together the best application, what to expect in the process. That's okay as long as it doesn't relate to a specific matter or transaction or application. That would be permissible contact with your former agency. If you're subpoenaed by if you are subpoenaed to testify, that can't possibly obviously constitute an appearance before your former agency. Training is another example, depending upon the circumstances, where interacting with your former agency might not constitute an appearance as long as they are not approving your hire as the trainee or approving the material you're training on. Again, this is just another example of you can have interaction with your former agency. You can even be paid by funds that come from that agency as long as the agency isn't exercising its discretion in hiring you or managing you. Another example is volunteer service at the request of a former agency. The first deals with transitions, people who leave state service and at the request of their former agency are providing institutional knowledge to help the new person transition into the position. As long as it's uncompensated, it does not constitute an appearance before your former agency. You're serving a public purpose and you're not being compensated. The same applies if you're asked as a former employee of a state agency to serve on a board uncompensated. Depending upon the circumstances, applying to your former agency for a certificate or a license may be a prohibited appearance. People leave the Department of Health and need to be recertified in order to continue to practice in their field. You can't prohibit them from moving on in life and practicing, so that's not considered a prohibited appearance. However, if you've just left DMV and you want to start a driving school, and the people you used to work with are the ones that have to inspect you and certify you and license you, that would be considered a prohibited appearance. Freedom of information requests. Very simply put, reaching out to your former agency with a freedom of information request. If it's on your own behalf, you can do it. If it's on behalf of anybody else, it's considered a prohibited appearance because the agency exercises some discretion in determining what exceptions may apply and what to turn over. Backroom services. The important thing here about backroom services, I've covered what it is. It's rendering services. Doesn't necessarily involve an appearance before your former agency. And the important part is the prohibition applies even if your former agency does not know that you're working on the matter. The idea being that in this instance you're using the specialized knowledge that you have from having recently left state service and how that agency operates to gain an advantage. So preparing documents for a private firm when it's reasonably foreseeable your former agency will review it. Assisting another person, advising them on how to prepare a particular application. Strategizing with someone in terms of developing a plan for influencing their former agency. These are all prohibited backroom services. The net revenues rule just basically dictates if you leave state service and you're working for a firm, it doesn't prohibit the firm from interacting and engaging in business with your former agency, but it does prohibit your ability to gain any profit from that. And these are more examples of prohibited backroom services: participating in a phone call, having someone drop your name. Again, this is just a rehash of what I said before. I'm going to go right past it in terms of being able to interact with your former agency as long as they're not exercising any discretion in terms of you being hired or managed. Another component of the 2-year bar that we interpret in applying it is whether or not a particular matter is before such a state agency. Again, this goes back to 99-17, where the particular DOT contract in that matter, once it had been approved, the designs had been approved, the funding had been made, all of the implementation of the project was handed off to a municipality. Because it was a municipality that was actually managing the project, the former DOT employee could work on that project because it was no longer a matter before DOT, so it didn't constitute an appearance. These are examples of what constitutes a matter before a former agency. And again, it gets back to this issue of foreseeability. If it's foreseeable that the agency, your former agency, is going to be involved in the matter in some respect, for example, the oil spill cleanup where a former DEC member can't participate in that, even though it's a matter before the controller's office, it's clear that DEC is still playing a role in that cleanup, so a former DEC employee would not be able to participate in that because it's still a matter before DEC. These are other examples of matters that are not before a former agency. I'm losing you, I can see. Litigation is another thing that gets split. If you're in litigation with your former state agency, if you're in court, you're before the judge, you're not before the agency, but it does significantly limit what interaction you can have with your former agency in terms of the typical things that happen in the course of a litigation, like settlement negotiations, discovery conversations. It all has to be through the fulcrum of the court. Important issue we confront is when does the clock start to run? Clock starts on the termination date. The termination date is the day you're off the payroll. Does not extend to leaves of absence, don't count. Being suspended without pay doesn't count. You're still an employee of the state. It's when you're off the payroll. Because of when the clock starts, you can have situations where people move quickly from one agency to another where they have not only more than one former agency, but more than one timeline. This is an example of a circumstance where someone went from one agency to another and then left state service. So essentially, they had two different two-year clocks running at the same time and overlapping. Exceptions to the post-employment restrictions. 3 common exceptions: the government-to-government exception, which simply put is if you're going to work for another state agency, federal agency, local municipality, the post-employment restrictions do not apply. This is codified in 73(8)(e). Sometimes in applying it, the question gets asked, what constitutes a governmental entity? This is a contrast. This is one case where the Commission held that the New York State Association of Counties was not sufficiently governmental in its operation to constitute a government agency to apply the government-to-government exception. Essentially, they were a lobbyist, and while they served some public function, they did not exercise sovereign power. On the other hand, you had the New England Interstate Water Pollution Control Commission, an entity that was sufficiently governmental in terms of exercising sovereign authority, that the Commission concluded it was a governmental entity and the government-to-government exception could apply. Another example that's been carved out in the advisory opinions are the closely affiliated entities. These are the research foundations. They're specifically defined in the finance law for OMH, Department of Health, and essentially, although they're not defined as state agencies, the Commission has held that the relationship is so close that a person can go from their state agency to one of these closely affiliated entities, still be serving a public purpose, so that the government-to-government exception should be extended to them. Then there is the certificate of exemption that you're all familiar with. These are instances where clearly someone falls within the 2-year bar, but the agency needs their services. They can't find them anywhere else. They can apply to the Commission for the right to an exemption to the post-employment restrictions. There's also the continuing health care exception, which was a recent addition, basically so that employees of the OMH, OMRDD, Department of Health, that when they leave state service, they can still go back to the facilities and treat those patients, and that the post-employment restrictions aren't interfering with the doctor-patient relationship. Finally, the executive law has some pretty stiff penalties for individuals that violate the post-employment restrictions, not only $40,000, but the recoup of any benefit that the person may have accrued. You survived.
I just wanted to say that these are, in terms of what takes up a lot of staff time and issues that are raised on a daily basis, this is a good part of our bread and butter. What we are intending to do with the presentation is actually add it, we're working on our website, turn it into a training and a primer for state employees so they have a map to the minefield. Also, I think one of the things we'll be doing is providing training to ethics officers in the various agencies, and as folks are leaving state agencies, making sure they've got this information in a usable form, so they can know how to behave and know what the consequences are of failing to behave.
Thank you, John, for a thorough and comprehensive presentation. Any members have questions or comments?
Dan or Seth, are we going to extend this type of presentation out to, example, deal with some of the things on the fringes of the 2-year, people leaving that are going to leave state service, and what type of relationship they could have vis-a-vis if that entity is also under state contract, the cooling off as you're walking out the door, and then on the other side, if you're out, if you're in government, you leave and then you come back to
On
government.
the reverse 2-year bar.
Yeah, but there is a reverse 2-year bar.
Yes,
that
there
we
is a
have.
reverse 2-year bar.
And there are advisory opinions on that. In terms of the issues you just fleshed out, certainly on the reverse
Covered.
2-year bar, we can give you, that will be part of whatever
Okay.
presentation we're doing. You sort of posit a hypothetical, which is something, something to look at, obviously. But these are the kind of issues that the commission may very well be confronted with.
Thank you.
All right. Well, thank you again, John. The last item, item 5, before we entertain a motion to go into executive session, is the publication of the commission's meeting schedule for the next 6 months. We've already scheduled meetings through the end of June, and this picks up the remaining part of the year. We've made some adjustments to accommodate folks' schedules, but now that that's been settled, we're going to publicize the remaining meetings so that folks in the public will know when our meetings will be in August through the end of the year. Unless there's any other new matters that folks want to raise, I'll entertain a motion to enter into executive session pursuant to Executive Law 94 subsection 19B. Commissioner Romeo moves. Is there a second?
I second.
All in favor? Raise your hand.
That's unanimous.
Any opposed? Seeing none, the motion is agreed to. We'll enter into executive session. When we complete our executive session, we'll return to the public session, and to the extent permitted by law, we'll report on the business that we conducted during our executive session.
We should have someone try and figure out what's wrong with these ones. I bet the batteries are dead. Can someone check them? New York City? New York City?
All right, we're back in the public session. During our executive session, the commission had a privileged discussion with its attorneys about 3 litigation matters that are pending. The commission authorized communications on 2 pending investigations. The commission authorized an extension in response to a 15-day letter. The commission opened 2 substantial basis investigations. The commission authorized a number of instances to communicate regarding investigations, to close an investigation with a guidance letter, and the commission discussed a number of pending investigations. Unless there's any other business before the commission, I will entertain a motion to adjourn until our June meeting, which is June 26th, is that right?
28th.
28th. All right, motion to adjourn.
Moved.
Second?
Second.
All in favor? Any opposed? Thank you, ladies and gentlemen, we are adjourned. See you next month.